Well, welcome to everyone. It's Law Before Lunch, and that means we have the jellyfish background because Law Before Lunch, it's not designed to be too heavy a law lecture for you. The idea is it's supposed to be short, no more than 20 minutes. It's designed to be informative as well. My name is Richard Stevens. I bring to the table 40 years plus experience as a lawyer. I've been involved in big technical litigation. I've been involved in huge global commercial deals. I now focus my activities on providing training, and I also work as a mediator and an arbitrator, and that's relevant to what I'm going to be talking about today, because I may, if I get time, have a look at some of the ethical points relating to a mediator when it comes to looking at a settlement agreement being negotiated in front of them at the end of a successful mediation. I said it's designed to be short. That means I have no time to blather. So I'm going to leap straight in with the slides, and therefore your 20 minutes starts from now. Let's have a go. Let's call that up. Okay, so you should have a copy of my slides in front of you now. I've called it compromise, but in what sense? The word compromise has a number of different senses. One of the good things about doing the job that I do is I get to look at all these contract cases as they come out. And it strikes me sometimes that they come along like London buses in twos and threes, dealing with the same issue every single time. But when I saw two cases to do with settlement agreements, and they used this time-honored expression, when I set them out there, arising from or in connection with, arising out of or in connection with, I thought this would be something interesting to talk about. You did too, because it's proved for a holiday season insanely popular. More than that, I mentioned two cases in my calling notice. I could add to that, over the weekend, I came across another one that's just come out in the last week or two. The first two said arising from or in connection with, arising out of or in connection with. The latest one says arising from, out of, or in connection with. Now, in two of these cases, the settlement agreement did not prevent a further action. In another one, it did. So I want to look into some detail as to why one of them was successful and the other two were not. The first one, I'll call the claimant Mr. Obaid. He was a Saudi businessman. And over a course of years, he made very large payments to Mr. Al-Hazami, the defendant. He said there were all agreements in place that Mr. Al-Hazami was supposed to dedicate this money to property investments. He brought proceedings in 2017. He said he'd made 24 of these large payments and the money had been misapplied or dissipated. In the same year, he substantially amended his claim. Of these 24 payments, no fewer than 15 were deleted from the revised statement of claim. There was one payment he'd made that was never mentioned in the pleadings at all. The trial started on the basis of the amended statement of claim, and after they knocked seven bells out of each other for a few days, they came to a settlement. It was recorded in the terms of a settlement deed. Set out there quite easily. You can have a look through it. Just ordinary recitals. Parties have been in dispute in relation to ownership of property and money. The parties wish to fully and finally resolve those disputes. I pause at this point only to say it all depends, of course, on your attitude to the split infinitive, to boldly go where no man has gone before. It may be you don't care about these things. I have to say I read that and I did wince a little, but I leave it entirely to you. It's your language and you can use it how you like. But it went on, there are the magic words, full and final settlement of all claims, but claims has got a capital C. So the I, of course, goes eagerly to the definition of a claim. And here it is. All and any claim of any kind arising out of or in connection with, those are those magic words. The English proceedings, well, that's a defined term too. So the I eagerly goes to the definition of English proceedings. And that simply was defined as the proceedings under claim number, blah, de blah, de blah. Well, that was the action where they'd had a few days knocking seven bells out of each other and they decided to call it quits. But the question was this. After the settlement deed, a year or two later, Mr. Obaid issued 8 further claims in Saudi Arabian courts for monies loaned and not repaid. The first of those 8 further claims was for a loan never ever mentioned in the English proceedings. It had never, ever been pleaded. The other 7 of those 8 further claims had been pleaded in the original claim, but they had been dropped from the substantially amended statement of case upon which the trial had been fought. So the question was, could the defendant, Mr. Al-Hazami, could he rely upon this settlement deed to stop the proceedings in Saudi Arabia? And the Court of Appeal said, no, he could not. It wasn't a general release. All that had happened in the settlement deed was to settle the claims as they had been strictly defined, and they were the claims in the English proceedings. It was, they thought, useful to look at the recitals. They disagreed with the trial judge on that one. They thought it was a useful background, and it set out very clearly that the parties were in dispute about the ownership of properties, the ownership of certain money, and what they had done is define the claim by strict reference to English proceedings. So it was those proceedings proceeding under that particular action number. And they said just because a claim had been deleted from the amended statement of case, it didn't mean to say that they couldn't bring that claim again. All that the settlement deed achieved was the settlement of the live issues as at the date of the trial. So therefore, the claimant, Mr. Obaid, could bring further proceedings for the completely unpleaded claim for the sum of money, and he could also bring proceedings for the sums that have been originally pleaded but then dropped by the amendment from the revised statement of claim. Let's take a look at this one. Dawnvale was a fit-out company. They were doing a fitting-out job for Hilgar, that was a property developer. There was no doubt that the contract was terminated. It was a construction contract, strictly so called, so it went to adjudication, and the adjudicator decided that Hilgar had lawfully terminated this contract for Dawnvale's repudiatory breach. He decided a revaluation of the work, and he decided that £180,000 were due from Dawnvale to Hilgar. Hilgar didn't pay. Dawnvale didn't pay. So Hilgar brought proceedings to enforce the adjudication as against Dawnvale. Those proceedings were themselves settled. The action, now a Tomlin order, means that the action is stayed, and you annex to the order a schedule that sets out the commercial terms. And the commercial terms were that Dawnvale would make stage payments to Hilgar. 2 years later, Hilgar had a second bite of the cherry, or perhaps it had a bite at a completely different cherry, because it brought proceedings for a substantial amount of money, and it was claiming for its losses following on from Dawnvale's repudiatory breach. It said it had suffered additional losses, the cost of remedial works, the cost associated with the delay, lost rent, lost profits, this sort of thing. Dawnvale said, well, we've come to an earlier settlement agreement in the Tomlin order, so you can't bring that further claim. Let's have a look at the terms. Well, the order in standard form said all further proceedings in this action are stayed. But then the schedule said that the payment of the settlement sum is in full and final settlement, magic words, of any and all claims the claimant may have against the defendant arising from or in connection with these proceedings. Now, were those words good and effective to stop Hilgar bringing that second action for the consequences of Dawnvale's repudiatory breach? And the judge said they were not. The proceedings, he said, was simply the action in which the Tomlin order was made. It didn't cover the underlying dispute at all. So any second adjudication and the related enforcement proceedings relating to that second adjudication would be different proceedings. He usefully looked at some of the law that's out there on the meaning of the expressions arising out of and in connection with. Arising out of, he concluded, imports some sort of direct causal relationship, much closer, much more proximate relationship than in connection with. He didn't mention the case that normally gets trotted out on in connection with, if that's the right word to use, pun not intended, in connection with, and that case is Campbell and Kanoko. And the Court of Appeal helpfully told us that "in connection with" was commonly regarded by draftsmen as being of the widest formulation, the broadest possible connecting link between two things. The judge accepted that "in connection with" was a much looser link, much looser nexus between two things. But even so, the settlement did not cover the completely separate matters that were being sued for and claimed in the second proceedings brought by Hilgar. Let's look at the latest case on this. Mr. and Mrs. Riley were property developers. They entered into huge loans with the NatWest Bank. The Rileys were alleging misrepresentations by the NatWest Bank. And what they were saying effectively was that the NatWest Bank had a policy, a corporate policy, of looking at non-core business. And they said their business was non-core to the NatWest. And what they would do was then drive them into effectively insolvency with a view to acquiring their assets at an undervalue and then realizing them at a huge profit. A profit, obviously, I should say, for the NatWest Bank, not for Mr. and Mrs. Riley. They entered into a settlement deed. At that time, the Rileys owed about £2.7 million, but they settled for a payment of, well, the lowest one was £1 million if they paid it within a year. That was settled by a settlement deed. After that, the Rileys said they found of public domain material seeming to show that, in fact, all their allegations against the NatWest Bank were correct, that the NatWest Bank had been pursuing a policy of driving non-core business into insolvency. And there were other instances of this, apparently. And there was a policy of trying to drive the assets into their separate group where they could be acquired at an undervalue and then sold on at a rich profit for the NatWest Bank. The question was whether the settlement deed, the terms of the settlement deed that they had entered into with the NatWest Bank, prevented them from making further claims effectively for fraud. Well, here are the terms of it. It starts in that first line, classic words, full and final settlement. And it goes on, hereby releases, forever discharges any and or all actions, claims, rights, demands, disputes and set-offs or other matters, whether or not presently known to the parties or the law, whether in law or equity, that it may have, or hereafter can, shall, or may have against the bank or any connected party, arising from, out of, or in connection with. And then it recited all their various obligations to do with the facility agreements, guarantees, and all the properties that they owned. Now, the question was, did this wording prevent the Rileys from reopening effectively the matter and accusing NatWest Bank effectively of deliberate concealment and fraud? And the Court of Appeal said that wording was in the form of a general release. And that meant that their original claim, which had been making allegations of deliberate misconduct, it had all been settled. And it was not possible for the Rileys to raise effectively the same matters again, having entered into a general release, releasing the NatWest Bank from further liability. When it comes to looking at releases, ordinary rules of construction will apply. And when you're looking at general releases, the classic case in modern times that people go to is the BCCI and Ali case back in 2001, where the House of Lords in that case was looking at cases on general releases going back, believe it or not, to the 17th century. There's a huge amount of law out there. And the earlier cases tended to talk about equitable principles. Nowadays, it's more a question of simply construction. Is this a general release or is it not? And if you have very general words saying, all actions that may happen in the future, whether you know about them or not, the courts will apply that. Although, as you can see from the BCCI and Ali case, the general release may not be quite so general as you might think. It's quite an interesting case. I'd recommend you have a look at it. It was a case brought by an ex-employees of the BCCI, and they had been made compulsorily redundant, and they'd entered into settlement agreements, including a general release. But after that, the law changed and allowed them a new claim that they could make against BCCI. And it went to the House of Lords and they said, well, the general release on a point of construction didn't apply to that new claim because the law had changed between the time of the settlement agreement and the time they were bringing the new claim. But they said they looked at some interesting situations. You've got a general release, will settle all claims possibly against you. But what, for example, if the employee had a bank account with the BCCI? Would that mean the BCCI could just sit on the money and refuse to pay it over to the ex-employee? And the House of Lords said, and indeed BCCI's counsel admitted no. The general release was only a release of those claims of the people who were suing in their capacity as ex-employees. It wouldn't affect their capacity as a depositor with the bank. A more difficult situation would be if they had some sort of claim for personal injury that was unknown at the time. Maybe they've been working in an asbestos-laden atmosphere, for example. Would a general release put an end to any claim in relation to mesothelioma? The House of Lords was a little bit more dubious about that. It might do, or it might not do. What do we make of all of this? As soon as I said to my wife I was putting on this talk, she said, well, the trouble with settlement agreements is they're very often drafted by litigators, and litigators don't necessarily make the best drafters. On the other hand, if they give it to their non-contentious colleagues, they may not necessarily be the best people to understand what the issues are in the case. So it's a bit of a tricky one. It's a bit of a minefield for the unwary. You need to understand the difference between a general release and a particular release. If you just include those magic words arising out of, from, or in connection with, or in any way in connection with, what the cases show is it doesn't necessarily turn your settlement agreement into a general release. It doesn't stop the claimant coming back for a bite at a completely different cherry. It's a general release. You need to think very carefully about what you are releasing. One of the things you may want to preserve if you're the defendant is your right to bring actions for deliberately concealed things or things that are relating to fraud. The courts won't necessarily require a general release to go as far as fraud. And again, if you look at the BCCI and Arnie case, they were saying that, well, if there had been aspects of deliberate concealment, fraud, as a matter of construction, it used to be equitable principle. As a matter of construction, the courts probably wouldn't allow a general release to defeat such a claim. I mentioned a mediation. Your role, my role as a mediator, it's a difficult one, and I can't tell you how many hours of CPD I've had, because the question they commonly ask is, if you're a mediator and you see one of the parties making a terrible drafting mistake in their settlement agreement, should you get involved? And the overwhelming majority of mediators will say, well, I'm supposed to be independent. I'm not there as counsel to one or other of the parties. And if one of the parties with its lawyers makes a terrible drafting mistake, so they think they're doing a general release, but according to this case law, they haven't. It's not for me to leap in and help one party as against the other. I'm supposed to be a neutral and I'm supposed to retain my independence. It gets rather harder, of course, if you see one party is really badly represented, or if you're dealing with a case between a consumer who is ignorant and unrepresented, and they're up against a big global corporation with wall-to-wall lawyers, and you see them basically getting legged over. At what point do you get involved? What point is it ethical to get involved? And some mediators, many mediators, might then get involved, not in the sense of doing the drafting for the consumer, but in saying, well, things like, well, look at this wording. What do you think if big global company did X, Y, or Z? Does this wording cover your concerns about A, B, and C? Things like that. You can't do the drafting for them, but you can, in a sense, point them in the right direction. But that's a difficult ethical question. And of course, it's not for the mediator at that point to get involved, and you can't help one party against another. Well, that's what I wanted to say today. If you liked what you heard today, if you think I provide good training, if you think I have any services as a mediator for you, please feel free to reach out and let me know how I can help you. In the meantime, you can buy me a coffee. Thank you very much indeed. I will stop my share. And if there are any questions, happy to take any questions there are. Otherwise, I have finished within my 20 minutes. Yes, that's right. I think many lawyers, the question is the problem arising from, out, or in connection with the scope of the things which follow the words claim X to contract the dispute. Yes, that's absolutely right. I think some lawyers think that in connection with, in some way, broadens out the scope of the settlement and turns it into a general release. And it's fairly clear law. It depends on the wording, of course, of your settlement agreement, but it's fairly clear law that those words are likely not going to turn your settlement agreement into a general release. Far more specific words are required. And it's, as I say, it's one of the things you get as a mediator, as you see the form of the settlement agreement taking shape before you, and unfortunately, as a neutral, you can't get involved and then suddenly take the side of one party against the other, trying to sort of turn a particular release into a general release. That's something that is much harder to do. Happy to take any other questions. Other than that, I wish you happy drafting. It is a difficult area. There's no doubt about it. If you are a litigator and you don't have long experience of drafting skills and you've got a complex settlement agreement to do, it's a difficult one. And if you get your non-contentious colleagues in, well, they may not have the experience of knowing what's in play in the dispute. So it can be a little bit of a muddle. But I will wish you no more questions on that. So I will wish you happy drafting and happy litigating. Hope to see you next time. This one has proved, as I say, insanely popular. And I thought doing it as we went into the holiday season, I would get no one along at all, but we went shooting past 100 delegates pretty quickly. So obviously there's a lot of interest in there. I've tended not to talk about settlement agreements in the past. There's quite a lot of litigation about them, but it tends to be quite detailed litigation on the specific wording without general points. I think on this one, there were some general points that I could usefully make. But I will thank you all for your attendance. All the best. If you want to hear from me in August, I don't know whether it's worthwhile putting anything on in August, and if there's something interesting, let me know. Other than that, I will see you when school is back, and have a happy holiday. Many thanks.